For cause case, People versus Marquise Hankey.
And is it on behalf of the people, Your Honor?
Good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Marquise Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey.
All right. And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor.
Quick pause. Yesterday's substitute defense attorney is already asking for an adjournment. Fair enough, but here's the twist. Delays like this can actually be part of a calculated defense strategy. Ever notice how often court dates get pushed? It's not always by accident. Smart move or just courtroom ping pong? Drop your thoughts below.
Respond appropriate.
Adjourned matter March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say. But
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located.
Boom. Major red flag. This guy cut off his ankle monitor and disappeared. That's basically telling the judge, thanks for the bail, but I'm gonna ghost the system now. Moves like this almost guarantee a bond violation and destroy any trust the court had. If you were the judge, how would you handle it?
And they stopped supervision. I also wanted to address his jail before he got out.
We have that?
No, we do not.
And you're aware of this?
I am, Judge.
Also wanted to address his jail calls from a court release.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell you, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Keita, who's the victim. He says, can't say that name on the phone, because she's my face. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well at a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
Here comes the spin. The defense is playing the young and scared card. First-time offender, panicked, thought he was headed to prison for life. It's a classic emotional appeal. But does that really excuse cutting off a court-ordered tether and disappearing? Stick around. This one's about to test where the line between fear and accountability gets drawn.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittedly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And hear me out, Judge. I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSC fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge,
Go ahead.
Community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught. And
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, go ahead, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's just playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bonded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point. But right now, he's remanded.
Thank you, Judge.
Your Honor, there are two matters, and we would like to adjourn to look into a global resolution. There's a district court matter as well as the
Which district court?
14A4.
Okay. So why are you telling me that?
We're adjourning for global resolution, Your Honor. Continue.
But I don't have that other one.
You don't.
I only have the felony.
That is correct.
So why are you telling me about it?
So, given the reason for the adjournment, we are.
No, I'll
Same
wait.
thing.
This is gonna be a long explanation.
Further negotiations is our reason for the request for adjournment.
I know, I see that on the form. So, all right. Chinaza.
Yes, sir.
All right. So when do you want this adjourned? So the other one is set.
Correct.
You could have stepped in earlier.
It is set for December 5th.
Got it. So you need this or after December 5th?
After is fine.
After the 5th. See, it would have been that easy.
We did the same thing.
I don't know how you were leading with whatever you were doing. But
We said the same thing.
what?
What she said, we said the same thing.
No, you didn't. You really didn't. December 12th, 2024, 9 a.m. Bond will continue.
One aspect. When this year was arraigned, she was not equipped with a GPS tether, despite the fact that we requested one. I am concerned that this case, that we have now 2 domestic violence cases rolling, and there is no GPS tether. I do know that there is a no contact order, as well. I would be requesting a GPS tether.
And Your Honor,
Go ahead.
the people did, Ms. Poisson did indicate that that would be their request today. When I spoke with my client, she indicated to me that that request was made at the arraignment. However, after arguments from both attorneys, the magistrate who arraigned her at the time indicated or decided that there was no reason for a GPS tether. There is a no contact in order. My case, or at least this case, was of January 2024. So she was arraigned, I think, subsequently on both of the cases when the new 14A4 matter occurred. So.
Well, when was the 14A4 matter? When did that one arise?
That it was Monday.
Well, it was also Monday, so it's right.
Of
Just
November 18th. This is January. So, and they were arraigned at the same time.
correct. I think the January incident, she was taken to the hospital, Your Honor, and then released, but she did not know that there was a warrant that had issued from that.
And that's this case.
That's our case, correct? Yes.
But I think the thing that I'm concerned about, Your Honor, is that we now have 2 domestic violence cases with this victim. And so even if the magistrate didn't believe that a GPS tether necessarily was appropriate in a case dating from January, with the addition of a new case, I think that it's necessary at this point.
Well, what was the rationale? You're saying it was addressed, but
Yes.
the magistrate's rationale in that I'm a bit perplexed by. Who's residing at the Valley Circle address?
We don't live there anymore. We moved out 6 months ago. 6, 7 months ago. No longer reside there.
That's even more concerning because that's the only address I have for the defendant.
The address that is associated with the other complaint, the new case, is on Riker Road.
Right. Okay, I see that. So the Riker Road address is whose address?
That's where her family lives, Your Honor, her husband
Where?
and children. She was living there before this incident. Before the new incident, the 18th, the incident of the 18th.
Okay, so I get that on Riker Road, but then the alleged victim was there also?
That's her husband, Your Honor.
Okay, but he was there also? They were
Yes.
both living there?
Correct, Your Honor.
So where is this defendant is residing where now?
I'm staying
She's,
in a hotel.
she's after the incident with the no contact order in place, Your Honor, she left from the home and she hasn't been there since her arraignment on the 18th. And again, the January.
So, and the alleged victim, her husband, is at the Riker Road address?
That is correct, Your Honor.
So who the
I think that's.
are you?
I'm sorry. Sorry, Your Honor.
You don't just leap up and start yelling. I don't care who you are.
Well, I was just.
Seriously? Guess that's taken care of. Okay, so I guess my concern is that I do have the second one coming around, and they're located initially at the same address, but now not at the same address, but her address is temporary.
Correct.
And then I'm going to Home of New Vision.
Correct. That was the
What?
next thing. She is slated to enter Home of New Vision on December the 3rd, Your Honor.
Got it.
So that's where.
And that other.
Yes, so she's already gone through the admission and the date that they have available for her is the 3rd. So she moves in on the 3rd from, yes, the hotel she's currently staying in now.
Okay. So here's what I'm gonna do. I am gonna order a GPS. I'll order it with exclusion.
If before the court does that, Your Honor, I do apologize. You did say it was going to be a long day. I apologize, and here I am.
Go ahead.
I know that the complaining witness is here today. My understanding is that